Thank you for joining me today. We're going to talk today about pretext evidence, common challenges that you might face. I'm also going to cover quickly a case where somebody was able to prove pretext, and then just to show you how pretext can work in your favor. So the first step in proving intentional discrimination is what's called a prima facie case. So the prima facie case just shows the basic elements that suggest that discrimination is a possibility. This typically means that you prove that you're part of a protected group, that you're qualified for the position, you're performing satisfactorily, you suffered an adverse employment action of some kind, and that circumstances show that it's certainly possible that discrimination has played a role in the events that are being challenged. It's a relatively low burden to have to meet to show a prima facie case. I'm not going to go into a lot of detail because it really depends on the circumstances, and it's not necessarily relevant to a pretext analysis. The second step is what's called a legitimate non-discriminatory reason. The legitimate non-discriminatory reason is what the agency claims is the reason why a particular action was taken. And they do have to show some evidence that this actually was what motivated the action. So for example, any kind of documentary evidence, a termination letter, emails, things like that. It's a very low bar for the agency to be able to show a legitimate non-discriminatory reason. In the proof scheme for pretext, what you're trying to show is that the legitimate non-discriminatory reason that is put forth by the agency isn't the real reason, that there's some other reason that isn't being stated. So this three-step process is typically what is being analyzed in a discrimination case. Is there a prima facie case? And what is the pretext evidence showing that the agency's reason for taking whatever action it did is false or wasn't the actual motivation for what they're claiming was the reason for why they took whatever action it is. This does not apply to a couple of forms of cases. So one type of case that it doesn't apply to is reasonable accommodations, because reasonable accommodations aren't about intent. You don't have to prove discriminatory intent. The failure to accommodate alone, which has its own elements that we're not covering here, reasonable accommodations don't require a proof of intent. Just the failure to accommodate is alone sufficient. It's really more about knowledge. Pretext and prima facie case, these are about proving that the circumstances show that somebody intentionally discriminated against somebody else. The other area where this is covered, direct evidence cases. There are few areas where they're direct evidence cases, but they primarily come up in the area of pregnancy discrimination, a lot of times disability discrimination. So a direct evidence case is where somebody explicitly states, I am relying on your protected class or protected activity to take an action against you. A lot of times pregnant women are excluded from opportunities at work because of concerns about their pregnancy or that they're going to have to take time off. For individuals with disabilities, a lot of times this comes in the form we don't think that you can work here because you're not safe, which is a direct threat issue. I can't cover that in this video, but I cover that elsewhere in my other videos. So please look for that if that's a situation that you're facing. But outside of that, the prima facie case and the pretext process is really how you prove a discrimination case based on circumstantial evidence, meaning somebody's not admitting that's their objective, that's their intent to discriminate against somebody using their protected category. Is how pretext was defined by the EEOC in 2018. If you look through this, it's very context dependent on the way that they are trying to show how you prove it. Pretext can be demonstrated by showing such weaknesses and plausibilities, inconsistencies, incoherencies, or contradictions in the agency's proffered legitimate reasons for its actions that a reasonable fact finder could rationally find them unworthy of credence. Okay, so let's break that down just a little bit. What you're looking for is a weakness, an implausibility, inconsistency, something that is incoherent, or just contradictions in what the agency is saying. What they're claiming is the reason for why somebody was terminated or whatever the action was. So a reasonable fact finder, that's just in EEOC cases, that's going to be your administrative judge. If you're in federal court, you're going to be talking about a jury. You want to be able to show that all of these reasons that are being given are so incoherent or inconsistent that they are unworthy of credence, meaning they shouldn't be believed. In these cases where we're trying to show pretext, we have to go beyond the surface level explanations. We have to get deeper. evidence that the reason that is being stated is not the real reason and is covering over for something that's more nefarious, something that is presumably discriminatory if it's not explained. So once you've proven your prima facie case, you have at least some level of indication that discrimination might have played a role. If somebody can't explain why they took a particular action, such as a termination, suspension, any kind of adverse action, now you're left with the conclusion, if that explanation doesn't pan out, you're left with the conclusion that it must be discrimination. If they can't explain it using legitimate business reasons, what other reasons are there? That's how pretext and the prima facie case interact, is that pretext wipes out the reasons being given, and the prima facie case brings back in, this is the reason for why this action was taken, even if the agency won't admit to it. Really what we're looking for are hidden discriminatory motives. A lot of this is about patterns. We're looking for somebody else's discriminatory purpose hiding in amongst all of these facts that otherwise they're just facts. Primarily, we're looking for patterns of behavior that don't make sense. Not just one or two single instances, but repeated instances, really as many as you can get, where a supervisor, manager, and management chain's actions just don't make sense given the circumstances. There is an EEOC case. I don't have the citation for you today, but in this case, there was a meeting that would happen, and the person who was assigned to take the notes for that meeting was always a woman, and it was always the same woman because she was the only woman there, apparently. But that pattern showed that this wasn't just a mistake. This wasn't just a, hey, we're doing this for everybody kind of situation. Everybody's going to take notes. It just happens to be your week. This is showing that somebody had some ulterior motive in giving this person the job of taking these notes. And it's discriminatory because she's the only woman there. It's consistent with stereotypes about women are supposed to do certain kinds of work, including secretarial work. And when it's repeated over and over again, it removes all doubt that this is simply a mistake. And so that's what we're looking for here. We're looking for multiple instances that can't be readily explained by the circumstances to remove any possibility that this is simply a mistake, or that it has nothing to do with qualities of this person, or that it's about somebody else. So in hiring cases, a lot of times it's difficult to prove discrimination because, for example, the agency management may want to hire a particular person for the job, but that's not discriminatory unless they're hiring that person because of their race, religion, national origin, any of the protected bases. So to be able to prove that there's discrimination going on, you need to show more than just that the person being selected is being pre-selected. It's the question of why. It goes beyond that. Why is this person being selected? And so it can be oftentimes difficult to do that. But if you have a pattern where the same person is a very highly qualified candidate and repeatedly gets turned down for people who are less qualified, then that strengthens the conclusion that it's not about the other candidates. It's not about somebody being pre-selected. It has something to do with this individual person. And if they're well qualified for the job, why are they not being selected, right? One time is maybe a mistake. Could be any number of reasons. 2, 3, 4, 5 times in a row. Now you're saying she must have been better than some of these other candidates. Surely just by pure chance, she would have been selected at least one of these times. The pattern recognition here is how we look for these discriminatory motives underneath the surface. In my view, and this certainly isn't something that is stated by the EEOC, but in my view, there are two general types of pretext evidence. The first is that the stated reason is demonstrably false, meaning the reason being given is not possibly a reason. I'm going to use here some examples. So the example I like to use is somebody being 5 minutes late. Somebody being 5 minutes late is usually not a reason for terminating somebody. Sometimes it is. Okay, but if the person isn't actually late, then that is a demonstrably false basis for firing somebody. If our hypothetical person shows up to work on time and then is fired for being late, well, the presumption is that the agency isn't just making up reasons for firing people, that there must be something else that's going on here. And that's where the prima facie case comes back in. Okay, are you treating somebody else better than this person? Are they being replaced by somebody outside of the protected class? That shows that there is, or that can show that there's discrimination. And that's how that scheme works. The stated reason being demonstrably false just shows that there's got to be some nefarious reason that somebody isn't bringing up, particularly if it's a flat out lie. Why would you make something like that up? It's a lot more difficult and tricky when the reason is at least in part true, or that it's something that is a matter of opinion. And that's when we get into the second type of pretext evidence, which is that the stated reason isn't being consistently applied. Typically, this is shown with comparators. Is there somebody else who is running afoul of this policy, but isn't being subjected to the same kind of treatment, suspension, termination, whatever the adverse action is? And if that's the case, then you need to be able to show somebody else in a similar circumstance is being treated differently. So given the example of being 5 minutes late, let's say our hypothetical employee is 5 minutes late. It's true, clocks in 5 minutes late, but her colleague who is outside of her protected class also clocks in 5 minutes late. Well, if that person's not fired, it certainly raises the question, why not? Why is one person being late subject to being fired and another person just gets away with it? Now, there can be other explanations that come on top of this, right? So the agency might say, okay, yes, we fired the hypothetical employee, but that was the 20th time that she was late. This other employee, that was his first time, right? We've given some warnings, we've given some letters of caution, those kind of things that would show, hey, these aren't really the same circumstances. Another thing that they could say is, that's a different office, different decision maker. That's not a comparable situation. That may or may not hold water. It largely does when it comes to the more opinion end of the spectrum. Whether somebody's late or not usually isn't subject to opinion. But for example, if somebody's work isn't up to what the agency claims is its standard, that's a matter of opinion. And that's a difficult position to have to fight from. And the more that it's about an opinion rather than something that is concrete, like being late, the harder it is to really fight through this process, the harder it is to show that's discrimination. And so I went through this example of being 5 minutes late and how these two general types interact with each other. Context matters. It really has to do with what the decision maker is thinking at the time. So as I discussed before, and I'll just point out again, the decision maker generally has to be the same. You can't compare different offices, different supervisors typically. We're looking for patterns of behavior. This is what really establishes the motive and the lack of alternative explanation. A clear pattern of treating somebody differently in a bunch of similar situations where it's unmistakable that person should not have been treated that way. That's going to go a long way to being able to establish that this isn't simply a mistake. It's not just simply this guy's having a bad day, the supervisor. This is actually a discriminatory intent. The intent is to get rid of somebody or to harm somebody because of who they are or because they engaged in protected EEO activity. I like to look for a constellation of unexplainable events. And you'll see in the case that I'm going to bring up in a couple of minutes what that means. But it really means that when you look at the overall picture, you can see a bunch of different points where things not only don't make sense, but they connect in some way. And even if it's a direct evidence type case or the reasons being given for something are demonstrably false, being able to point to somebody who is a comparator to be able to say, I'm being treated differently than that person over there, that really helps judges, juries to be able to make a decision. So in understanding pretext, it's hard to talk about pretext without talking about examples because the definition of pretext is so broad and wide open because it can cover almost any kind of scenario. It really requires understanding cases, understanding circumstances to be able to pull out what constitutes pretext evidence. So this is the case Gordon v. the Secretary of the Army from 2013. This is from right before they stopped using people's real names. You can find this on the internet. If you go to the EEOC's website, you can just type in, they have federal sector cases that they publish online from at least 2000 onwards. You can just type in the case number that's listed here, and that will take you to this particular case. But long story short, this person had a huge increase in her workload volume, and she was given short deadlines after she filed an EEO complaint. So she filed an EEO complaint, and then within a few days, her workload really went through the roof, and the deadlines became very short for completing that. She's also been denied the assistance of her coworkers, so she can't go to her coworkers to be able to get any help on meeting these deadlines. And she was even given these deadlines when she was doing something that the agency knew was more important than meeting these deadlines, but they were forcing these deadlines on her. The increase in the workload, that went unexplained why that was. What the agency claimed is that the workload was within this person's job description. That doesn't really explain why there's a huge increase in the workload right after she files an EEO complaint. That doesn't explain that at all. It explains why she could be given this work, but why was she given this work? So the EEOC really focused in on that and said, hey, I don't really understand this at all. This is not a good explanation. It might be true that she could be assigned this work, but nothing here is explaining why she was assigned this work. So your explanation isn't really an explanation at all. And that you would put that forward in this situation really leaves us with the impression that you don't have a reason. So the second thing that happened was she got a reprimand for taking sick leave. That's not a common situation. In fact, you're not allowed to reprimand somebody just because they took sick leave. In this case, the employee had requested sick leave actually in advance. I think she had surgery. It's going to take a week to recover. She also provided them afterwards with documentation showing that she actually went into surgery and was homebound for a week. Maybe the agency could have taken issue with the fact that if you knew about it sooner, you could have let us know about it sooner, but that's not what they justified the sick leave reprimand for. It doesn't make sense to give somebody a reprimand for taking sick leave, particularly if it's completely justified. Not only that, but in this case, the agency wasn't able to show that they disciplined anybody else in similar circumstances. Those comparators were very helpful for the EEOC in determining that this didn't make any sense, that this reason being given was just pretext to cover over for some other probably unlawful motive. And finally, one thing that really stuck in the EEOC's craw was that when she went to go talk to the EEO office, she was told that she had to use her annual leave to be able to go and do that. They have to keep open the door to the EEO office, and they can't say, you have to self-fund talking to an EEO counselor. By doing that, it strongly suggested to the EEOC, the agency was very unhappy with this person going to the EEO office. And that helped to then enhance this explanation that, hey, none of these supposedly legitimate reasons hold any water. The real reason here is retaliation. They want this person gone. They want to do whatever they can to make this person's life really a living hell because they don't want to deal with complainers. Just to summarize here what pretext evidence is, the devil is in the details. And that's where you need to go in and find out more information to help you understand how this all fits together, what the constellation, which I brought up before, what that constellation actually looks like. And you definitely want to have more than one single piece here. If we go back to the prior case, Gordon versus Secretary of the Army, there are at least three. And within those three, there's multiple pieces here where things don't make sense, right? The increase in workload, unexplained. The explanation itself was so unexplanatory that it really just suggested that there was something more going on here. You've got multiple levels here where the explanations don't make sense. And when the agency falls back on these explanations that don't make sense, and then the way that they fall back doesn't make sense, that just adds to their problems. So thank you for your attention today. I hope that this has opened up some areas for you to understand evidence in EEO cases, in particular pretext evidence, and how it works with the prima facie case. If you're facing discrimination or retaliation in your federal workplace, I really think you should talk to somebody who knows and has experience with federal employee EEO cases